The Supreme Court on July 17, 2024 deferred the ruling on a request to restrain Parliament from transmitting the anti-LGBTQ bill to the President for assent. A five-member panel chaired by the Chief Justice Gertrude Tokono adjourned the case indefinitely until the substantive case is heard and determined. This move is what has enraged sponsors of the bill who perceive it as a deliberate delay in getting the bill passed. Ningo Prampram MP Sam George says the Chief Justice is acting maliciously, hence the protest to demand a timetable for the case hearing.
The Family Values March is a march not targeted at the President but at the Chief Justice. The Chief Justice is becoming an impediment to the justice delivery system in this particular case. We are going to petition the Chief Justice to give us a timeline for the completion of the case. There was a ruling that was supposed to be given on the 17th of July. She came and unilaterally decided to stay that ruling. She cannot impose an injunction on Parliament so moto. It is an abuse of her powers under Article 296 of the Constitution. She's acting arbitrarily, she's acting capriciously and maliciously, and we will take her on for that and hold her to account for that.
The legislator has fought claims that he has influenced some high officers to endorse this protest dubbed the Family Values March.
The National Chief Imam, His Eminence, Sheikh Nuhu Sharabutu, will be influenced by me, his son or grandson, that the Christian Council, the National House of Chiefs, Numo Belenfo, President of the Osu Traditional Council, who have all endorsed this march, the Ecumenical Council, the Catholic Bishops Conference of Ghana, I, Sam George, is influencing them. That I'm more powerful than I know. I don't sit in Parliament because I'm handsome. I sit in Parliament because members of the public voted for me and put me there. So I work for them. This march is as a result of a call that has come from the people, and I'm heeding the call of the people.
There are two lawsuits before the Supreme Court challenging the passage of the Human Sexual Rights and Family Values Bill. But Sam George maintains that the Chief Justice cannot hold the functions of Parliament and the Executive.
She's adjourned the case sine die, which means it could be in abeyance for 2 years, 5 years, we don't know. What the Chief Justice has done is that she has put Article 106 of the Constitution on ice. The Chief Justice alone has held the hand of the Executive and the hand of the legislator. She can't be that powerful. People have occupied that office before her, and one day she'll be held to account for her actions or inactions.
The Attorney General, Godfred Dame, earlier welcomed the decision of the Supreme Court, saying it is in order. But some fear the case may not see any progress based on the prevailing circumstances. Christian Yale, TV3 News.
Meanwhile, private legal practitioner Martin Pegbo, reacting on this development, said it would be unfair for the Chief Justice to allow the anti-LGBTQ case to be considered before several criminal cases pending before the court for years. Take a listen.
So what they are doing, as I said, is within their right. Let them do it. I think that's a very strong way of going about it. But we've also said they shouldn't stampede the court, because I can cite you many other cases where we thought that those were urgent, but the court took years. So this is their right to do, but we also have other contending, claims, which we are saying that we also have cases pending in the court. We don't see how the anti-LGBTQ should be heard ahead of our cases, because those people in Sawam, they are also citizens. The people doing their criminal appeals, they are also citizens. Theirs are more urgent because right now they have lost their freedoms. So Sam George, yes, he may send a petition to the Chief Justice. We're also urging the Chief Justice to look at our criminal cases. In fact, when you go to court, the criminal cases are supposed to receive the priority over any other cases.